the shared ownership. So we talk about the fundamentals of condominium ownership, including high rights, highlighted provisions from the Condominium Act. Um, we'll talk about the legal structure of the condominium established by the way of declaration and description, differentiate between common elements, unit, and calculate the common expenses. Related to those common elements, identify and discuss different types of condominium available in Ontario. Um, Identify various identified the various types of condominium available in Ontario, identify various provisions in the Condominium Act relating to the leasing and sale of unit, discuss information contained in the certificate and the role of reserve fund in the condominium, differentiate between equity and non-profit cooperatives, and detail financing challenges associated with this form of ownership, and discuss timeshare arrangements and differentiate between fee ownership and right to use timeshares. Overview. Statutory provisions have been enacted to deal with some shared ownership concepts. These concepts include condominium, time sharing, and cooperative housing. The concept of condominium is an ancient device to permit separate ownership of individual units of a property and shared ownership of common areas. In Ontario, condominium ownership was created by a statute. The owner in fee simple creates a condominium by registering the document called a declaration and description. Upon registration of these documents, a corporation with all the share capital is formed. The object and the duties of the corporation are to manage the property and administer the common elements and corporate assets. The corporation is financed by the common expenses used by the unit owners. The revised Condominium Act uses the term status certificate rather than the extopel certificate. The legislation also provides for the creation of four new types of condominium corporation: common element, phase, vacant, and leasehold. Time sharing is a variation of the condominium concept in which the condominium is registered with all the normal provisions of the unit, but with additional provision for buyer's interest in the unit and the common elements to be restricted to a particular time period. With cooperatives, there is a cooperation formed to own the real property. Buyers buy the shares of the property of shares of the company and acquire the right to occupancy through the tenancy with the corporation. Condominium. A condominium involves the freehold or leasehold ownership of a specified amount of space or the unit in the multiple dwelling environment with tenancy in common ownership or the portion jointly used jointly with other owners or the common elements. A condominium enables a person or the other entity to share in the ownership and the operation of the residential or commercial complex while having negotiable title to the individual unit. Condominium is not a new concept. The term condominium originates from the Roman term referring to the joint dominion or the co-ownership. This form of condominium was introduced in Ontario approximately 40 years ago. Provincial legislation. The original Condominium Act dates from 1967. The Condominium Act 1988, a substantial document containing 189 sections, represents a compilation of proven procedures and concepts from previous legislation combined with new and innovative approaches to explaining the world of condominium ownership. Legal structure. A condominium legal structure is established through the declaration, aptly referred to as the condominium constitution. The condominium legal structure is established through a declaration, commonly referred to as condominium constitution, and the description. A condominium is created in law when both declaration and descriptions are registered. The owner of the land invokes the Condominium Act through this registration process. Registered encumbers, such as a mortgage or lien holder, must consent to the declaration and invocation of the Act. The corporation will a corporation with all the share capital is automatically formed rather than corporation upon incorporation in which the members are the unit owners. The land registrar for the applicable land registry office gives the corporation a name and a sequence number. The object of the corporation centers on the management of the property and the corporation assets. These functions are paid for by the unit owners through common expenses promotion specified in the declaration. The corporation has the duty to effect unit owners' compliance under the Act. The declaration and the bylaw and has the power to own, acquire, encumber, and dispose of real and personal property. According to the bylaw, the corporation does not provide limited liability. The unit owners are personally liable for all the debt and obligation of the condominium corporation. The Condominium Act. Real estate practitioners involved with new or resale condominium unit should carefully review both the Act and the regulation, as well as pursue advanced education courses of condominium. A board of directors elected pursuant to the Act and the bylaw consists of at least three members, three or more number as specified in the bylaw. Directors are required to be a minimum of 18 years of age and cannot be undischarged bankrupt or mentally incompetent person. A director ceases to be director if either of the two latter event occurs or the individual concerned does not obtain a discharge for a lien related to the payment of common expenses within 90 days of the registration of that lien. Directors are appointed for a 3 year or such lesser period as specified in the bylaw. All business of the corporation is conducted at the meetings of this board of directors. Directors must adhere to the standard of care in their role by acting honestly and in good faith while exercising care, diligence, and skill of a reasonable person in carrying out their function. Directors can rely on good faith on the financial statement reports and opinions of relevant experts and are not liable should a breach of duty occur. Directors may be indemnified and saved harmless by the corporation, and the corporation may acquire appropriate insurance. However, such protection do not apply if the director acted dishonestly and not in good faith. Standard bylaws are the standard rules regarding condominium internal operations that involve governance. For example, establishing procedure for borrowing funds, setting director remuneration, and other regulatory matters. Bylaws are made, amended, and repealed by the board of directors and must be consistent with the act and the declaration. Bylaws are not effective unless the owner of the majority of the unit vote in favor. A copy must be registered in the land registry of it. The registered bylaws made by the declarant are valid until they are replaced. Common elements. All property within the condominium corporation except the units are known as the common elements. The clear definition of the universe common element is essential, and the practitioner must understand the scope of the ownership when listing or selling condominium. Common elements are held by owners as tenant common in proportion as set out in the declaration. One or more owners may have exclusive use of selected common elements such as parking space and balconies. A board of directors may make an addition, alteration, or improvement to the common element without the owner's approval unless the owner requests a meeting and vote against the proposed work. Addition, alteration, and improvement of substantial nature require approval of the owner who owns 66% of the unit. Owners may make addition, alteration, improvement to the common elements but are subject to the board approval, formal agreement, and other criteria set out in the Act. To recap, the board of directors can make addition, alteration, and improvements to the common elements without owner's approval unless the owner requests a meeting and vote against the proposed work. Addition, alteration, and improvements of substantial nature require the approval of the owners who own 66% of the unit. Common expenses. Common expenses are those costs related to the performance of the object and the duties of the corporation, including all expenses specified as common expenses in the Act or in the declaration. The payment of common expenses and the amount of such expenses is an important consideration when purchasing condominium. Owners contribute common expenses in proportion to outlined in the declaration. Any default can result in a lien against the owner unit, which can be enforced in the same manner as a mortgage. No owner is exempt from this requirement, even if he or she has waived or abandoned the right to use common elements, is making a claim against the corporation or is restricted from using such from using such common elements. The right to register a lien for common expense areas, previously limited to residential condominium in prior legislation, now includes non-residential condominium. Condominium corporation. A condominium corporation is a corporation without share capital formed coincident with the registration, declaration, and description of condominium. A condominium corporation is unique in that it does not fall under the Corporation Act but is subject to the regulation of the Condominium Act. Owners share assets of the corporation in the same proportion as the interest in the common elements. A corporation is managed by a board of directors consisting of at least three members. The primary objective includes the control and management administration of the common elements and assets of the corporation, along with the compliance of owners, occupiers, and leasing. The corporation is governed by five documents: ob- object declaration, bylaws, rules, and statutory provisions of the Condominium Act. Condominium corporation type: common elements. This type of condominium corporation consists only of the common interests held by owners in those common elements, but having no units. All reference to the unit or the proposed unit in the Act are deemed to reference to the common elements, common interest in the corporation. The common element condominium corporations represents a significant advance in condominium legislation. Such corporation must be freehold, not a vacant land or a face condominium. Each owner of an interest in the common element must uphold a free parcel of land to which the common interest applies. So to recap, there are basically four types of condominium corporation. Common element condominium, leasehold condominium, phase condominium, and the vacant land condominium. So in the case of a common element condominium, this type of condominium corporation consists of only of the common elements held by owners in those common elements, but having no units. All reference to the unit or proposed unit in the Act are deemed to refer to the common interests of the corporation. The common elements condominium corporation represents a significant advance in the condominium legislation. Such corporation must be freehold and not a vacant land or a phase condominium. Each owner of an interest in the common element must own a freehold parcel of land to which this common interest applies. Upon registration of the declaration and description, the common interest of the owner attaches to the owner's parcel of land and remains attached even if the home is subsequently sold. A golf course, ski hill, park, or a road might be a common element condominium in which owners are required to pay for maintenance, repair, and modification. Common element condominium represents a new concept in Ontario marketplace. Detailed procedure requirements and remedies for common element condominium include important variations from other type of condominium that go beyond the scope of this descriptive test. Leasehold. This form of condominium is a corporation in which all the units on appurtenant common interests are subject to the leasehold interest by the owner. All leasehold interests in the unit along with the common element must be for the same term. A leasehold interest in the land can be divided into units and common elements and subject to registration of the declaration and description to describe as a leasehold condominium. Each leasehold interest and appurtenant common interest is valid even if the leaser is the owner of that interest. Leasehold interest and appurtenant common interest are for the same term. Leasehold terms cannot be less than 40 years and cannot be more than 99 years. Owners of the unit do not require consent to transfer mortgage, lease, otherwise deal with their interest. In case of a face condominium corporation operates as a freehold corporation in which the declarant may may create additional unit or common element within the corporation. The term phase refers to the additional unit or common element that are created in accordance with the Act upon the registration of an amendment to both the original declaration and the description. The phase condominium provide flexibility for declarants in the development process by permitting the registration of an initial development as a condominium and then being permitted to bring in successive units or common elements under the single condominium corporation. Under the previous Act, declarants involved with large development had to register individual condominium corporation when involved with large projects involving several buildings and or phases. The ability to bring successful units or common elements under a single corporation produces economy of scale that is, avoid the need for several board of directors within the large development. Further, the grouping of several phases offer bulk buying advantages when purchasing services, for example, utilities. Vacant land. A vacant land condominium provides for the development of and sale of land without the necessity of immediately connecting completing structures. Developers can market condominium corporate condominium ownership, complete services and related infrastructure, sell lands to buyer subject to building requirements and register the condominium corporation all, all prior to any construction occurring on individual land units. Lands are transferred to buyers with homes and or other structures and are also just to be built later. The declaration represents contain restrictions concerning future construction like building size, design standards and commencement and a completion time frame. Ownership interests are based on the land sizes. The unit owners must provide insurance for building and structures on the unit. Bylaws can be passed regarding minimum maintenance requirements for the unit. Declarant must build any building or structures on the common elements prior to registration and provide a bond or the external security for subsequent construction. The security is released once all the building structures, facilities, and services are completed and approved. A standard condominium is a freehold condominium that is not a that's not a common element. Vacant land condominium or vacant land condominium. Condominium corporation created prior to the new Condominium Act coming into force are classified as a standard condominium. The declaration of the condominium that effectively creates a condominium and sets out responsibilities of the declaration is the constitution of the condominium that effectively creates a condominium and sets out the responsibilities of the owners and the corporation. The declaration, along with the description, is required for the decision of the condominium corporation. The Act outlines for both required and optional items. If any item in the declaration is consistent with the Act, the provision of the Act prevails. Declaration content varies according to the condominium type, standard, phase, vacant land, common element, and the leasehold. But the items that are most commonly used are found as statement that the condominium act governs the land and the appropriate interest, consent of the mortgagees, proportion interest of each unit in the common element, proportion interest of each unit in allocating expenses to the common in allocation and division to the common expenses, address for services, municipal address, and mailing address, part of the common elements used by one or more designated units and not by all owners, common elements, common expenses of the condominium corporation, conditions or restrictions concerning occupation and use of units and or common elements, responsibilities of condominium corporation consistent with its objects and duties, allocation of obligation to maintaining units and common elements, including repair after damages in accordance with the Act. Description. A diagrammatic representation of the property and any structure within the condominium corporation is referred to as a description. More specifically, this includes such items such as a plan of survey, architectural plan, structural plan, boundaries of each unit, diagram showing shape and dimensions of each unit, a surveyor certificate, and a description of any interest apperent to the land that are included with the property. So description is a diagrammatic representation of the property or any structure within the condominium corporation. More specifically, this includes such items such as the plan of survey, the architecture plans, structure plans, boundaries of each unit, diagram showing the shape and dimensions of each unit, the surveyor certificate, and the description of any interests apparent to the land that are included with the property. Disclosure requirements for the new unit. Stipulations are set out in the Act involving forthright disclosure concerning the purchase of a unit or proposed unit from a declarant. Each person who purchases a unit or proposed unit from the declarant must receive a copy of the current disclosure statement. Required content from a disclosure statement are set out in the Act. A buyer has certain rights associated with the delivery of disclosure documents. The buyer may rescind an agreement of purchase and sale and receive a refund of all monies given if rescission is made by the purchaser within 10 days of receiving a disclosure statement. So let's look at the disclosure requirements for a new unit. Stipulations are set out in the Act involving forthright disclosure concerning the purchase of a unit or proposed unit from a declarant. Each person who purchases a unit or a proposed unit from the declarant must receive a copy of the current disclosure statement. Required content of the disclosure statement also set out in the Act. The buyer has certain rights associated with the delivery of disclosure statement. The buyer may rescind the agreement of purchase and sale and receive a refund of all the monies given, including interest, if the decision is made by the purchaser within 10 days of receiving the disclosure statement or receiving a copy of the agreement of purchase and sale, executed by the declarant and the purchaser, whichever is later. If a material change occurs in the disclosure statement, a revised disclosure statement must be delivered to the purchaser within a reasonable time. Similarly, in the case of a material change, the buyer has certain rights regarding the decision of the agreement of purchase and sale. First board. The board of directors required within 10 days following registration is appointed by the declarant. The first board consists of at least 3 members who hold the office until the turnover meeting. The first board meeting must be held within the earlier within the must be held before the latter of the first board meeting must be held before the latter of 30 days after the declarant transfer 20% of the unit, 30 days after the declarant transfer 20% of the unit, or the 90th day after the first unit is transferred. Before the latter, so the first unit should first meeting of the board should happen before the latter of 30 days after the 20% of the unit are transferred, or 90 days after the first unit was transferred. At this meeting, the owners may elect 2 more directors who will hold office in addition to those appointed by the declarant. The first board must call a turnover meeting to elect the new board not more than 21 days following the time when the declarant ceases to be the registered owner of the majority of the units. Interim occupancy. Interim occupancy involves the circumstance in which the purchaser occupies a proposed unit prior to receiving a deed in the registrable form. Practitioners will encounter interim occupants in the new condominium project. A buyer has the right to pay any unpaid balance of the purchase price on certain interim occupancy. Buyers can either elect to do so by paying such unpaid balance at the time the agreement is signed, or within the time period statutorily permitted from rescinding the agreement 10 days following the letter of receiving duly executed statement of purchase and sale of the disclosure agreement. A monthly occupancy fees is payable by the interim occupant, which includes the monthly interest on the unpaid balance of the purchase price at the prescribed rate, a reasonable monthly estimate of the municipal taxes, and the projected monthly common expenses contribution. If the purchaser is charged a monthly occupancy fee for more than 6 months, the reserve fund component of that fee following the 6 months period must be held in the trust by the declarant and remitted to the corporation upon registration of the declaration and description. Lease of unit. The owner of the leased unit are required to notify the condominium corporation within 30 days of leasing or renewal of a lease and provide details regarding the leasing name and the owner's name, and along with a copy of the lease. Practitioners should be aware that the prescribed form is provided for this purpose. The owner, Form 5. The owner must furnish the leasing with a copy of the declaration, the bylaws, and the rules of the corporation. The owner must also notify the corporation of the lease termination if it's not renewed. The corporation is required to maintain a record of all notices received. Practitioners should note that the term lease for purpose of Condominium Act includes subleases and assignment of lease. Parking. The initial disclosure statement of a new condominium details whether or not parking is allowed on a unit or on the common elements or in the exclusive area within those common elements along with the restrictions. Further disclosures must be set out when visitor parking is available, what costs, if any, apply, and if no visitor parking is available, what other facilities exist and where. Practitioners most frequently encounter parking issues in resale unit. Buyers need to be carefully Buyer needs to carefully review all documentation provided with the status certificate to determine which type of parking is provided and what parking spaces, if any, are included with the unit. Parking can be generally um, grouped under the following four types. Freehold. A unit owner owns a parking space either within the unit or with the unit description or separate title. If the latter, the unit owner is typically permitted to sell the space to another owner in a complex at the fair market value. However, restrictions regarding such matters should be fully investigated. Leasehold. The condominium corporation retains the parking space and leases them to the unit owners. Exclusive use and common elements. The condominium corporation owns the parking space but grants the right to use specific spaces as set out in the declaration. Allocated or assigned. The condominium corporation owns the parking space and assigns space to the unit owners on a discretionary basis. Performance audit. A performance audit is the detailed examination and scrutiny of the common elements by an individual with qualifications set in the Act. This audit includes inspecting major building components, reviewing condominium documentation, and conducting a survey of owners in considering damages and defect. The individual then prepares and submits a written report to the board of directors. Requirements concerning performance audit apply to the condominium corporation with one or more units used for residential purposes and the common element condominium corporation. The person conducting the audit must hold a certificate of authorization of Professional Engineers Act or certificate of practice. The audit is designed to reveal deficiencies that may arise that give rise to the Ontario New Home Warranty Program claim, whether or not the corporation falls under the program. The reader is reminded that ONHWP coverage is restricted to new residential condominium and is further subjected to other qualifying criteria. If a material auditors may enter the building at a reasonable time, either alone or accompanied by appropriate expert, um, requiring require the production of relevant documents and take examination tests or inquiries as deemed reasonable. Performance test must be completed no later than 10 months following the registration of declaration or description. Reserve fund. A reserve fund is used solely for the major repairs and replacement of common elements and the corporation as such as roof, building, exterior finishes, roads, sidewalks, electrical heating and plumbing system, and recreational parking facilities. Funds are collected from common elements and must be held in trust. Interest or other income from the reserve fund forms a part of that fund. If repair costs to common elements exceed the monies in reserve, a special assessment may be required to meet such expenses. Repayment terms can vary considerably, but essentially the unit owners are required to contribute a specific sum in addition to the normal monthly common expenses. When a condominium is first registered, and until a first reserve fund study and an anticipated plan is completed, the reserve amount is greater of the money reasonably required for major repairs and replacement based on the expectancies and replacement costs or 110% of the budgeted amount for the contribution to the common expense. exclusive of the reserve fund. Corporations are thereafter required to undertake reserve fund studies in accordance with the prescribed time limit. Such ongoing studies, among other things, determine whether the existing funds in reserve and the contribution collected are adequate for a new condominium. Following the proclamation of the Condominium Act in 2001, the reserve fund study must be completed in a year following registration. Within 120 days of the receipt, the board must establish the plan for future funding. Within 15 days, provide owner with a summary, and within 30 days for following, implement the plan. Rules. The rules involve directives and regulations developed by a condominium corporation that promote safety, security, and welfare of the owner's property and assets of the corporation. Rules also prevent unreasonable interference with the use and enjoyment of common elements. Practitioners should be aware of the rules impact the condominium being marketed, as they can directly impact the purchaser. The board of directors can make, amend, or repeal rules that are reasonable concerning the common elements. The board must provide owners with a copy of the rule, the effective date, and the notice that may requisition a meeting. Rules are not effective until approved by the owners at a requisition meeting within 30 days. If no meetings is requisitioned within that period, the rules become effective. Sale of new unit, sale by declarant. A condominium act contains provisions regarding the sale of a proposed and or the new condominium unit. The owner or developer referred to as a declarant must fulfill various disclosure requirements set out in the Act. The buyer may rescind the agreement with written notice within 10 days of the delivery of the disclosure agreement statement or the receiving of the copy of the agreement of purchase and sale by the declarant, executed by the declarant and the purchaser. Any deposit concerning the right to enter into the agreement on account of the agreement of purchase and sale or on the sale or account of sale concerning a proposed unit must be held in the trust by the declarant, solicitor, or the trustee, or prescribes class as set out in the regulation. The first 20,000 of the deposit in the case of New residential condominium will be covered by the deposit protection and the Ontario New Home Warranty Program. For the sale of resale unit, the Agreement Purchase and Sale Condominium Act 101. The Agreement of Purchase and Sale Condominium Resale is designed for resale condominium transaction. A copy of body form 101 is included. In addition to the preliminary clauses unique to this form, real estate practitioners should clearly delineate what is included with the property, storage locker, and parking space. Further, any improvements or addition completed by the owner should be discussed and duly noted. A status certificate issued by the condominium corporation sets out important details regarding the resale condominium unit and the condominium corporation. Status certificate. The status certificate is a document containing information regarding the operational, legal, and financial dimensions of the condominium corporation. The corporation is required to give each person so requesting and status certificate with respect to the unit in the corporation. Practitioners should be familiar with all the aspects of status certificate. Certificate must be provided within 10 days by the corporation to anyone who requests this document. A prescribed fee not to exceed $100 inclusive of all taxes can be charged. The information contained within the status certificate and the accompanying document are vital to the buyer prospective in fully understanding both the status of the individual unit and the overall operation of the condominium corporation. Status certificate includes corporation address for services, statement of common expenses, amount payable by each unit for common expenses, particular for any increase in the common expenses, a statement concerning any assessment related to the reserve fund since the date of the budget for the current year, information concerning any application regarding amendment to declaration, details of an outstanding judgment, status of any legal action against being taken against a condominium corporation, uh, current or budget or most is audited statement, copy of the current declaration, bylaws and rules, a listing of various current agreements, a statement that a person requesting the certificate has the right to inspect agreements, owner compliance with the current agreement regarding modification that relate to the unit, particulars concerning most recent reserve fund study, numbers of unit lease for the current year preceding the certificate, date, certificate and memorandum of the current insurance policies, Any planned or proposed addition, alteration, or improvement to the common elements. Estimate if the court has appointed us inspector pursuant to the Act. The person paying the fee for the certificate can, upon written request, also inspect certain agreements like management and insurance. Copies will be furnished for a fee. Upon written request, the names and address of the for service of the corporation directors and officers and the person responsible for management and the individual delegated to provide such certificates can also be obtained. The Act also sets out the requirement in the event that information is omitted or the certificate is not provided when requested. If any information is omitted, thus the statute provides that the certificate states there is no such information. When the certificate is requested and not provided within the required time frame, that's 10 days, the Act states that the certificate is deemed to have been provided and that there is no default in the common expenses, no increase in the common expenses has occurred, and no levies have been assessed against the unit. Again, the storage locker can be freehold, exclusive use, leasehold, or allocated. Termination. Condominium corporation can be terminated in four ways. By consent, consent is required of owners of at least 80% of the unit. Further, at least 80% of the person having registered claims against the property created following registration of declaration and description must also give their consent. Within sale of the property, the Act ceases to govern the condominium if the property as a whole is sold. If a part is sold, the Act governs ceases to govern that part. Then 80% majority vote is required. One of at least 80% of the unit. If the common elements are being sold, only if the common elements being sold are only for the use of the owners of specified unit, then those owners may consent to the sale subject to the other provisions in the Act. When the property is sold, the unit owners share net sale proceed as per the proportionate ownership share outlined in the declaration. Proceeds from the common area designated as exclusive unit for specified owner are divided between the owners in proportion to the respective ownership. Substantial damage. If the condominium suffers damage, the board of directors will assess scope of such damage and determine if it is substantial. Substantial for the purpose of the Act is when the cost of the repair exceeds 25% of the replacement cost of all the buildings and structure within the property. The owner is notified accordingly. Upon receipt of such notice, the meeting of the owners can be requisitioned by the owners within 30 days. If the owners of at least 80% of the unit consent, a notice of termination must be registered within 30 days. If no vote occurs in favor of termination, then the corporation is obligated to make the necessary repairs. Court obligation. The Ontario Court General Division, upon application by the owner, mortgagee, or a corporation, may terminate the condominium corporation according to the criteria set out in the Act. Let's talk about the turnover meeting. A turnover meeting relates to the transfer of control from the declarant to the owner. The turnover meeting must be not more than 21 days following for the time and then the declarant ceases to be the registered owner of the majority of the units. Four objectives are addressed in the turnover meeting: election of the new board, document delivery of or declaring delivery of documents at the meeting, declaring delivery of documents in 30 days, declaring delivery of documents within the 60 days. So the document delivered at the meeting are seal of the corporation minute books, copies of all agreement entered into by the corporation, copies of all insurance policies, bill of sales, transfer of items, record concerning owners and mortgages, record concerning leasing of units, and any other records relating to the units and employees of the corporation. As-built architecture, structural engineering, mechanical and electrical plumbing plans, existing warranties or guarantees, as-built specification, all existing plans for underground sites, services, documented into Ontario new home warranty, ownership, owner or corporation responsibilities, details of what constitutes a standard unit, corporation financial records, or reserve fund statutes, most current disclosure statement, and the declare and delivery of document within 60 days generally constitutes audited financial statements. A unit is a portion of the property so designated in the description and broadly described as a space defined by the boundaries within, including all the land structures and fixtures within that defined space. For the purpose of the Act, all units are deemed to be the property, with each owner having exclusive ownership and use of his or her unit. Unit can be are clearly differentiated from common elements held by the owner as tenant in common. Unit versus common element. The effect of condominium corporation is to divide the property into units and common elements. Apparent into each unit is a proportionate ownership share of the common elements. The proportion of such units are specified in the declaration. Each unit owner owns his or her unit separately, together with undivided interest in the common elements. Each unit owner is responsible for the proportionate share of common elements, which is also set out in the declaration. Use restrictions. Use restrictions generally refer to the limitation placed on unit owners as found in the declaration bylaws and or rules. Such restrictions are established initially by the declarant and modified by the condominium corporation as needed. Use restrictions vary significantly in the condominium. There could be a use restriction like for no pet while back on exterior debris material with temporary dry debris is allowed during the initial moving period only. No no inside installation. Parking is restricted to private passenger vehicles only. No commercial vehicles. No sign permitted other than those approved by the corporation. No temporary structures, incidental or permanent, outside the structural improvements. No artificial vegetation. No outside sewage of garbage, trash. No awnings, and garbage and garage doors must be closed at all times. Now, the second more important aspect is or type of housing option is are the cooperatives. So again the cooperatives are various types. There's the housing cooperatives, there's the equity cooperatives, and also non-profit cooperatives. A housing cooperative is an incorporated business pursuant to the Cooperative Cooperation Act in Ontario, organized by the individual which who joined forces to acquire housing through through joint ownership. Currently, Canada has 21,000 to 2,100 housing cooperatives, with approximately 25% of those located in Ontario. Generally, cooperatives provide high level of security of tenure, not typically found in rental properties. Cooperative housing has proven attractive to individuals who seek to avoid the uncertainties of rental market while deriving the benefit of combined financial resources in the acquisition of affordable housing. Cooperatives originally gained popularity with the university campus as they provide affordable accommodation for students. Cooperatives, as member-controlled organizations, are managed by the board of directors, consisting of members, elected persons for the membership. Members pay pay a monthly housing charge to cover mortgage and operating cost. Housing charges rise with the increase in the operating costs. Unlike rent, they respond to the market conditions, operating costs, and the provisional legislation in some instances. In Ontario, a housing cooperative is formed to own real property. Members may or may not hold shares in the cooperative, depending on whether or not the property is an equity or non-profit cooperative. In the case of equity cooperative, it has a share capital. An equity cooperative is a corporation which owns the land and building with the members as shareholders in the corporation. Ownership is by the way of share certificate in combination with the occupancy agreement related to a specific unit. The occupancy agreement may also provide exclusive use of parking or locker space. Cooperatives and condominium must be clearly differentiated. In the case of cooperatives, the individual holds shares in the corporation, while in the condominium, ownership is by the way of title to a specific unit. Non-profit cooperatives without share capital um, has the primary objective of providing housing to its member without the purpose of gain for those members. At the point of resolution, the cooperative will distribute any remaining property without payment of liabilities. in one or more non-profit housing or cooperative or charitable organization. Agreement of purchase and sale cannot be used in the acquisition of equity cooperatives, because there is twofold process. A share is sold and the occupancy agreement is created or assigned. So there's a separate agreement purchase and sale form 102, which sets out the real property we granted by the means of exclusive right to property to occupy and use, together with any parking space or lockers, and the appropriate share being purchased in the corporation. The agreement also requires that the purchaser, on or before closing, enter into the occupancy agreement with the corporation and abide by the rules and regulation of that corporation. Such associated with the sale includes full search of title to the property as well as cooperative cooperation. As no interest in the land is being transferred, the new owner is provided documents in support of the new ownership, namely the new share certificate, redemption of the occupancy agreement, other particulars concerning right being acquired, amount of mortgage, rules and regulations, and bylaws. The Business Corporation Act permits corporation to place restrictions on transfer of share. Consequently, anyone contemplating the purchase of and sale of a unit should be aware of what restriction exists, the process required to obtain approval, if such do not exist, and associated timelines and the cost. Land transfer tax applies to the purchase of cooperatives, despite the fact that the share is being sold, not an interest in the land. Equity cooperatives present special financing challenges because of that property must be mortgaged as opposed to the condominium with distinct ownership. Cooperatives the co-op mortgage is effectively a blanket mortgage over the that property with the joint liability of the owners in relation to the proportion share. This poses several complications when acquiring a suite in the equity cooperative. The buyer must assume the applicable liability for the proportion share of the mortgage and then secure secondary financing. Often lenders are reluctant to advance fund based on the pledge of security and the assignment of collateral security, which is the occupancy agreement. The cash purchase is of course another problem because the buyer must be assured of that any obligation of the previous shareholder related to the share is paid. A cooperative typically provides for approval by board of directors for any pledge of share. They've been introducing another element into the transaction process. Cooperative owners are responsible for proportion share of any blanket mortgage and also has potential for any obligation of other owners should these owners indeed fail to meet their financial commitment to the cooperative. Let's look at the Cooperative Corporation Act. The Financial Services Corporation of Ontario regulates regulation of the organization which conduct businesses um, as cooperatives under the Corporation Act. The FSCO is the arm's length agency of the Ministry of Finance. Cooperatives are members owned and controlled organizations. The Act does not regulate day-to-day business of a cooperative, including the bylaws which are established for its operation. The legislation does provide that all members equal that one member equal one vote, regardless of the amount invested. That was set out the statutory requirement concerning offering statement and related disclosure when securities are sold beyond basic membership shares and when surplus distribution occurs at the point of termination. Section 4, 5, and 6 of the Cooperative Corporation Act detail the registration requirements. The procedure for real estate cooperatives require that a specific number of individuals file an article of incorporation and other prescribed elements and pay the required fees to FSCO. The FSCO then issues a certificate of incorporation. Detailed registration process, filing and record keeping requirements and information concerning offering statements can be obtained from the credit union and the cooperative branch. Type of cooperatives. Well, housing cooperatives are discussed in this chapter. Various other types of cooperatives exist. For example, service cooperatives, consumer cooperatives, supply cooperatives, marketing cooperatives, producer cooperatives, childcare cooperatives, financing cooperatives, farming and supply cooperatives, milk transport cooperative, worker cooperatives, and housing development cooperatives. Some cooperatives issue securities to their members, and in certain instances, to the restricted categories of non-members. Cooperatives can be incorporated with or without share capital. Individuals investing in cooperatives normally do so to realize certain personal goals, for example, availability of goods and jobs. Cooperatives in Canada have various support organizations. In case of housing cooperatives, regional and provincial legislative association exists as well as various agencies provide development and management services. Co-ownership. The concept of co-ownership It's a unique variation of the other condominium and cooperatives experience some popularity in Ontario, particularly in the mid-1980s. The buyer in a co-ownership building receives a deed in addition to the occupancy agreement. The deed represents the proportionate interest held in the building in relation to other owners in other tenants in common owners, but does not relate to a specific unit within that structure. The issuance of a deed together does not alleviate the most troubling situation already identified under the cooperatives, namely joint liability with other owners with regards to the blanket mortgage, the difficulty of securing secondary financing, and other issues that go beyond that are more complex. Now, let's look at timeshare. Timeshare involves the division of property rights into fractional interests based on time. Timeshare ownership has proven most popular in the sale of recreational properties, particularly in the case of southern vacation resorts. Timeshare is a relatively new concept in property ownership that generally falls into two broad categories: fee ownership interest and right to use ownership. The fee ownership interest is right to encumber, convey, or otherwise transfer the interest of all for all future time. Right to a non-free fee interest in designated property in which the buyer receives no registrable title. Instead, the owner of this interest has a contractual right to enjoy the use of the property for a specified period. Then the concept of time as a divisible dimension in the ownership was never contemplated in the original provincial statutes and regulation underlying either register land titles. Consequently, a certain degree of creativity was required to accommodate the intricacies of several owners occupying various time frames in a specified unit. Fee simple ownership is probably the most straightforward method to acquire an interest in timeshare. Initially, a condominium corporation is created and registered in the condominium corporation index of the applicable registration office with appropriate pages set up in the parcel register. Initial weeks are registered under the unit, with all the 52 weeks being displayed with the percentage interest in each of the periods. The sum of all the interest must total 100%. A transfer number is assigned when the week is conveyed to the owner. The resale of this interest, either back to the declarant or the other party, is recorded in the chronological order under the unit register. The initial transfer from the declarant is typically accompanied by a notice of agreement. This agreement generally binds each of the owner in the to the restrictive covenants, rules, regulations, and bylaws of the timeshare condominium project. With a fee simple ownership, when a fee simple ownership is conveyed, the new owner must also sign the notice of agreement, ensuring the continuance of such compliance. Now, in case of right to use ownership, there is no registrable title. Title to the land and the improvement rests with the developer, corporation, or the association, and there is no need for a condominium corporation. Each owner obtains notice to lease that designates specific weeks weeks acquired, conveyances through the notice of assignment of the lease. Uh, so now, in case of if the property is under the land titles, any lease greater than 3 years must be registered on the title for to have any validity. If the property is under registry, then the period is 7 years. Right to use lease does not usually exceed 20 years. As with fee simple, the conveyance of interest is cost reference to minimize confusion given the large number of leases involving one specific unit. Consumer Protection Act. Consumers have certain protection under the Consumer Protection Act for the timeshare. Every timeshare agreement should be in writing, should be delivered to the consumer, and should be made in accordance with the prescribed requirement. A customer may, without any reason, cancel a timeshare agreement at any time from the date of entering the agreement until 10 days after receiving the copy. In addition to the right under Section 1, a consumer may cancel a timeshare within 1 year after the date of entering into the agreement if the written notice is not provided. I think with this we are done with chapter 11. Let's recap. Condominium is legally structured by the way of declaration and in description the property within the condominium corporation except the units as referred to as the common elements. Owner contribute to common expenses in proportion to set out in the declaration. A condominium corporation is a corporation that without the share capital. A condominium corporation is a corporation without share capital formed with the registration of declaration and description. Condominium types include standard common elements, leasehold and phased. Owner of the lease premises in the condominium must notify the condominium corporation and provide certain details about the tenancy arrangement. Carefully review the condominium documentation to assess what type of parking and locker space is provided. The condominium corporation is required to give each person so requesting a status certificate with respect to the unit in the corporation. Unit restrictions can vary significantly from one condominium to another. Housing cooperatives are incorporated business pursuant to the Cooperative Corporation Act. Timeshare involves division of your property rights into fractional interest based on time. Timeshare can be grouped broadly into fee ownership interest or the right to use interest. I think with this we are done. Thanks for your time.